Senate President, distinguished colleagues.
After about 2 invitations to appear before the Senate Committee on Judiciary, Human Rights and Legal Matters, the Attorney General of the Federation, Mr. Abubakar Malami, finally shows up. His appearance is linked with the court suits against the 2 principal officers of the upper legislative house, the Senate President, Mr. Bukola Saraki, and his deputy, Mr. Ike Ekweremadu. The 2 and others are alleged to have forged the Senate Standing Rules 2015, which saw Mr. Bukola Saraki and Ike Ekweremadu emerge as the choice of the Senate as principal officers on June 9, 2015. The event turns controversial, giving room for accusations and counter-accusations.
2016, otherwise pray with us.
It is against this background that the federal government filed a 2-count charge, maintaining that the defendants, by their conduct, committed an offense punishable under Section 91, subsection 1, and 364 of the Penal Code Act.
Shalom, yours sincerely, Senator Emmanuel Boacha.
On June 27, when the accused persons appeared before the court, the trial justice, Yusuf Halilu, after listening to pleas, released the defendants on bail, even as he okayed full-blown hearing into the matter. All 4 pleaded not guilty to the offense.
We don't intend to disturb the conduct of the legislative business on the floor of the Senate. And so there was no reason to oppose his bail, since the offenses for which he is being arraigned before the court are bailable offenses.
Well, the prosecution is doing the traditional job of a prosecutor. Ordinarily, I shouldn't see any reason why bail should be objected to. But being a prosecutor, he has to do his job. And we, on the other side, have to do our job. But the Administration of Criminal Justice Act is very, very clear. It makes bail very liberal, except if there are reasons why you feel that bail should not be granted. Like they raised the issue of likelihood of the defendants not coming to take their trial, but they didn't show any reason why they feel they cannot come to take their trial, particularly considering the status of the defendants. Mekasua, the first defendant, is clerk to the National Assembly, equivalent of head of service. The second is his deputy, second accused. The third accused and the third defendant is the Senate President of Federal Republic of Nigeria, and the fourth defendant is his deputy. I can't imagine them running away from trial. Where are they going to run to?
The matter is again called up, but this time to be scrutinized by the Senate Committee, which represents the upper legislative chamber, which had voiced out its objection of the trial.
Shall we pray?
Tagging it a witch hunt and a move by the federal government to weaken the institution.
I thank Mr. Chairman.
The chairman of the committee sets the tone for the meeting.
I apologize quite profusely, I must say, for his inability to attend at the last invitation. And he explained further that even the fellow that came did not actually represent what he stood for. The office Yes, sir. Is that different from the criminal case?
That is the criminal case.
Okay.
I'm saying there are two cases.
Yeah, okay.
The civil case instituted by the members, yes, and the inactive, yes. And then the criminal case, which was instituted by the Office of the Attorney General, arising from the normal course of business of the office.
Let me get to speak for himself. Excuse me.
One after the other, members of the committee seek answers on issues at stake. And chief amongst them is whether Justice Malami's decision to file charges of forgery against the leadership of the Senate is in the interest of the nation.
Neither the president, the courts not to exercise jurisdiction over acts of president or speaker or officer. Neither the president or speaker, as the case may be, of a legislative house, nor any officer of a legislative house shall be subject to the jurisdiction of any court in respect of the exercise of any power conferred on or vested in him by or under this act, or the standing orders of the legislative house, or by the Constitution. You see, this particular section here guarantees that the legislature, their private and domestic activities should not be pried into by other arms of government. You see? And what we have here is that the Senate have taken a resolution. And taken a resolution on the matter, taken on the rules of the House, the Senate standing orders, 2015 as amended. We have taken decision. This is our decision. This is accepted. And we say we are working with it. And the standing orders, there are several letters pending before the Senate that we are going to consider based on what we have already considered and agreed by a resolution that this is our stand. And then some dissenting voices amongst us here, being aided, are questioning these directions. And I'm asking the Attorney General, with a view to that 174.3, the public interest, whether is protected, or an abuse of the office of the General, whether you are not infringing on this Section 30 of Legislative Houses and Privileges Act to go and continue doing whatever thing you want to do. This is part of the questions I asked that we want answers.
I had expected, frankly, that at the beginning of your submission, you probably would have given some form of apology, for not honoring the previous invitation. I assume you would do that in the course of this, proceeding. Now, having said that, let me state ab initio that I do understand the position you've taken, that the matter is sub judice. I frankly wasn't expecting anything less from you. And I say that taking into account the decisions of the court, especially with Bagudu and Federal Republic of Nigeria, E.G. Ondo and the Attorney General Federation. All those cases, including the Loris, actually make clear, no doubt, that your discretion under 174 is unfettered. You are pretty much a law unto yourself, not my word, the word of the court. But having said that, I still want to ask a very simple question. I'm not seeking an explanation. You don't owe us one based on the decisions of this court. But having said that, I want to ask you, can you tell us, because you are not just the Attorney General of the Federation alone, you're also a minister in the Temple of Justice, can you tell us that in exercising your discretion to prosecute, you took into account the public interest?